security of the people. On the other hand, pretrial detention means the most severe infringement of personal rights of people still presumed innocent. It violates the freedom of these people and it risks their physical and psychological integrity. In Europe, about 1/4 of all prisoners are pretrial detainees. And just for the member states of the European Union, this means that on an average, every single day of the year, more than 100,000 people are in pretrial detention. And research quite clearly shows that pretrial detention is overused in many jurisdictions. If you have a look at the graph, you can see that just among the partner countries of the pre-triad project, the rate of pretrial detainees per 100,000 of the population varies between 8.6 and 32.6. I don't want to go into any detail here. I just want to draw your attention to the fact that there are huge differences between the countries. Of course, detention rates ignore relevant national differences with respect to crime structure, social conditions, demography, migration, etc. But research also shows and proves that there are considerable differences in the detention practice. It is about differences in the legal cultures, and it's about differences with respect to the standards applied. This means we actually share legal principles, but we put them into practice differently. And I mean, this is quite irritating because the value of personal rights is supposed to be the same in all countries, and this must be particularly true for the European Union. Let's have a look at the shared principles which are supposed to protect the pretrial detainees. We share the principle of legality, which requires a strict adherence to the law. No one may be deprived of his freedom arbitrarily without the legal requirements be fulfilled. And Article 5 of the European Convention on Human Rights actually requires a restrictive interpretation of the grounds allowing violations of personal freedom. Then the presumption of innocence is something we share. This is very fundamental, but it is particularly vulnerable if we think, for instance, of preventive grounds for detention. The presumption of innocence appears very easily threatened. Then we have the ultima ratio principle, which defines that pretrial detention is supposed to be a measure of last resort. Pretrial detention is a subsidiary measure which may only be applied if it is needed to secure the proceedings and to prevent further serious offenses or threats to society. And it only may be applied if these objectives cannot be attained with alternative measures. Then the principle of proportionality. This asks for a cost-benefit calculations. It is about the seriousness of the offenses, about protective aspects, and the possible sentence on the one hand, and the massive violation of personal rights imposed by pretrial detention on the other. If we look at those principles closely, we'll learn that there's quite some leeway for interpretation. International studies reveal a practical preference of the authorities in many countries for detention rather than for alternatives. This definitely calls into question the strength of these principles and the standards applied in this respect. The wide margins of discretion also become visible if we look at the assessment of the grounds for detention. In prior research, I've learned that the grounds for detention often appear exchangeable. For preventive grounds and for flight risks, often the same criteria are used, like for instance, the economic situation, social circumstances, social ties, and practically margins of discretion are definitely necessary for the practitioners to put the law in practice. But on the other hand, these leeways, these margins, are actually also an entrance for motives for the intention, possibly violating the legal principles. Aiming at common standards, we have to be aware of these threats, to an appropriate application of pretrial detention. What are these risks? Procedural economics may, for instance, prevail, although there are no criterion to be considered. Pretrial detention is simply the easiest way to secure the proceedings and to promote the investigations. For instance, a regular place of residency in a European member state is supposed to largely exclude the assumption of a risk of absconding. In practice, this principle seems to be ignored very often in many countries. Also, performance metrics may motivate judges and prosecutors to opt for the easiest solution. What is the easiest solution? It's pretrial detention. Then there may be punitive reasons which are part of the motivation to order pretrial detention. The notion that pretrial detention may teach the suspect a lesson, for instance, is at least close to punitive motivation. And if no prison sentence is expected to be the outcome of a trial, pretrial detention may be used as a sort of substitute to punishment. We have observed that. Sometimes pretrial detention is also called to be in the interest of a suspect if he's expected to receive a prison sentence anyway. It is claimed that the whole court and prison episode is put behind faster. Firstly, this ignores the presumption of innocence. Secondly, this ignores the particularly difficult situation pretrial detainees often face. And last not least, this ignores the fact that free suspects have better chances to avoid a prison sentence. Public perceptions and media commentaries also have a potential to influence the decision makers. On the other hand, there's also a risk that pretrial detention is used for general preventive reasons, to warn others not to get involved in crime. This cannot be a ground for detention because we talk about people considered innocent. And last not least, it is an absolute no-go to use pretrial detention to pressure a suspect into a confession. Although we may not ignore that there are suspects hardly apt to avoid pretrial detention, it is a well-established fact that an extensive use of pretrial detention causes severe problems on different levels. Pretrial detainees represent a large proportion of the prisoners in many jurisdictions, and in fact, pretrial detention is a relevant factor contributing to prison overcrowding. This brings about substantial problems, above all for the detainees, but also for the prison administrations. The administrations have to handle the difficult situation, and on the other hand, they're still often blamed that they don't fill the mandate. Prison overcrowding is a central factor contributing to undignified, sometimes even dreadful conditions of detention. For instance, too little space available, hygienic and health-related problems, insufficient medical care, lack of ventilation, lack of natural light, and additionally, most often this means a lack of individual treatment, of individual care, as well as a lack of activities. Most often, pretrial detainees are confined to the prison cells for more than 90% of the days. It is absolutely no surprise that such conditions often violate acknowledged international standards. For the detainees, pretrial detention regularly seems to be even harder than serving the actual sentence. The potential individual problems are often stressed by practitioners working in the field. Social consequences, financial burden, loss of jobs, impact on social ties, family problems, and last not least, the detainees' mental health may suffer considerably. The negative psychological consequences are dramatically expressed in the high numbers of suicide rates among pretrial detainees reported from some countries. In the end, the problems caused by an extensive application of pretrial detention also affects the state and society as a whole. Apart from the high costs for the prison system, there are many hidden costs behind pretrial detention. The problems affecting detainees and their families, for instance, often lead to a need for public social support, unemployment money, etc. And the stigmatization and the experience of detention bear a high risk of individual downward developments, possibly also leading to new offenses. So it's actually in the interest of all of us, of the whole state, that we use pretrial detention as rare, as solemn as possible. In comparison to pretrial detention, alternative measures cost only a fraction. If I talk about cost, I mean cost in the broad sense, not only monetary, but also the other consequences. National reports, however, most often stress a very little use of alternatives. If we take the ultima ratio principle seriously, and if there is a need for measures, alternatives to pretrial detention should be the first choice. In Ireland, for instance, this is the law in practice. Every suspect threatened by pretrial detention is entitled to bail unless the prosecution can convincingly argue against it. In most countries, on the other hand, alternatives rather appear to be second choice. It's a fact in many places, possibly even most places, there's quite some room for improvements with respect to alternatives. But little use of alternatives is not necessarily due to lack of options. It seems to be a widespread phenomenon that decision makers have rather little trust in the suitability of alternatives. This is often aggravated by insufficient information available for the selection of suitable measures, aggravated by the little time available for the decisions, as well as aggravated by possible organizational hassles. But we have to keep in mind, favoring alternatives to pretrial detention, one, however, must not forget that these alternatives are also restrictions to liberty, which only may be ordered if there's a real need. And the principle of proportionality also needs to be considered with alternatives. Generally acknowledged and realized standards on alternatives to pretrial detention could be an important step towards an increased and appropriate use of pretrial detention. People living in difficult social conditions are on a considerably higher risk of being subjected to pretrial detention than others. Foreigners often meet this characteristic, and additionally, they often lack a permanent residency in the country when they are apprehended, suspected of having committed a crime. Therefore, in many European countries, foreigners are overrepresented in pretrial detention. In Austria, for instance, about 3/4 of all pretrial detainees are foreigners. 3/4. In Portugal, the situation is not that extreme, but still, 1/4 of all detainees also means an overrepresentation. Practically, this means that the problems related to an extensive use of pretrial detention can only be solved if the high percentage of foreigners is appropriately taken into consideration. We must think of it. And with foreigners, the puzzle to solve is even more difficult because with them, in fact, it is more difficult to apply alternatives. The EU has therefore developed the European Supervision Order. Abbreviated, it's called ESO. The ESO is supposed to foster the application of alternatives to pretrial detention with EU nationals. With the ESO, EU nationals can be released from pretrial detention with alternative measures monitored in their home country. The ESO is, however, also an explicit message of the European Commission of the Union valuing the application of alternatives to detention. Unfortunately, in practice, the ESO, however, still remains mostly unknown among legal practitioners. In Austria, for instance, not a single ESO request has been documented so far within 5 or 6 years by now. Apart from time pressure, obstacles that weigh heavy are related to the needed cross-border cooperation. This objective actually asks for common understandings, for continuing efforts towards common standards, and last but not least, it asks for mutual trust. Cases like the Aranyoshi and Calduraro, which shed light on unbearable conditions in detention facilities and on big difference in the detention standards among the European countries, have actually contributed to a weakening of the mutual trust among the EU member states. There's very much need for improvement with respect to the realization of common standards. As long as the shared standards are open to extensive interpretations, and if they don't effectively contribute to change of the wide range of differing practice, their value remains very much restricted. There's a need for more guidance and a need for more clear definitions of the fundamental principles. The rulings of the European Court on Human Rights require alternatives to be ruled out when detention is applied. But obviously, this direction is not sufficient. There's a need for more concrete guidance and standards with respect to the application of alternatives, with respect to their nature and their content. The rulings of the European Court on Human Rights could give stronger and more detailed directions. Possibly, it is also necessary to resharpen our legal foundations in this respect. There are, however, also other options to raise awareness about the nature of pretrial detention, to promote a common understanding and common standards among the legal practitioners. The provision of cross-border information, of possibilities for exchange and of common learning are important steps towards common standards, towards mutual trust, and towards better cross-border cooperation. Apart from the research objectives, this is what the Pre-Triad project is about. Thank you, and I'm open for questions. Anybody with us?
Has to say, many legal rules, such as proportionality and so on and so forth. And I ask you, groundly, which are the main questions deal with proportionality? Because I think that we don't have a coherent ruling on that, not even a coherent application on this issue. It is very hard. And we also see that when in a globalized world, as we are, that also the legal orders are distinct, are very different. They have different patterns, and which could be some measures which can help us to apply this legal ruling, such as proportionality, in order to make also the decisions more coherent and more certain, which is actually what we are not looking at it now. I would like to hear you on that, Professor, if you would.
Yes, of course. that's what I tried to express in the final part of the presentation. We are in need of more guidance in this respect. I don't fully agree. I mean, I don't know all national legal solutions on pretrial detention, but I've studied quite a few, and they are not that distinct. And as I said, we share those principles, which should be the fundamental basis for the standards. And still, our application is a huge variance. What is needed is actually what I say is the work on the common standards. And I think, to be honest, I think the European Court on Human Rights actually leaves too much open in this respect. We would need more detailed rulings in this respect. I mean, it's not sufficient that the European Court says there's a need for more alternatives. There's a need for quite concrete guidances when alternatives have to be applied. But of course, this the whole responsibility cannot be with the court. I mean, possibly, but this would be a question really for legal scientists, for specialists. Possibly, we should rethink, resharpen the detailed regulations, maybe even in the European Convention. But I think at least as important is this exchange among practitioners. If we share common understandings, if we continue, if we cooperate together more often, I think this also is a chance to practically come together to develop common standards. Of course, the problem is this takes a lot of time. But this is one of the reasons why I'm really in favor of European projects also involving the practitioners, because we do exchange those things, and in fact, we don't have to invent the wheel over and over again. If we exchange, we may, in the long run, learn to understand each other. One of the most difficult things, of course, is like I said, are the difficult situations, the terrible standards we have in some prisons. I mean, of course, this costs a lot of money to kind of rebuild those prisons in some countries. But in the long run, this is something definitely has to be changed. Otherwise, we will still have problems with the European arrest warrant. Other countries will not really execute it. And it's right that they don't. And if there's built up some pressure, I think some countries will be under pressure to adapt their standards. There must be plans, there must be steps towards those goals. But I think then we go in the right direction. And it's the same. This is the same with the principle of proportionality.
Many thanks, Professor. We have actually come together because sometimes it seems that law and the practice are speaking different languages. They are speaking and acting together. And sometimes what I feel is that the judges or even other ones do not have the certainty or can't see the impact that some of those laws and some of the pre-trials has actually in society. I think that society mostly think that the prisons are the best solution, prayer trial are the best solutions, but I think that you pointed it rightly out, that we should also think that alternative measures to prayer trial, because prayer trial is actually a measure which put the person outside the society for a long time, and we don't have a final solution on that. Could you please explore these pre-trial alternatives, because they are really very interesting, and I don't heard talk about it in the Portuguese system from
Well, it's not. In fact, it's not that easy. There's no real common acknowledged definition of alternatives to pretrial detention. What we now in the pre-trial project, we actually in the first place we kind of distinct between measures supporting alternative measures. We've learned that in some countries they already start with preparations for alternatives in the round of the decisions. So we know that the more information about the offense and about the offender is available to the judge for the decision, the better is the chance that alternatives can be applied. So in some countries, there are, for instance, institutions like called court aid, or the probation services even do it. And in Portugal, I've learned that the social services of the prisons actually do this kind of evaluations of research on the offender to really provide a good basis for the decisions. So this is a first, in my opinion, very, very important step. And then the second step, of course, are the alternatives by itself. And there's a huge, actually, variance of measures there. I mean, the easiest things actually offered everywhere are just things like reporting to the police or to the court, which, in my opinion, doesn't really do very much. But on the other hand, we also have alternatives like electronic monitoring. And this is another problem because electronic monitoring actually is very intrusive as well. There's not that much difference. I mean, they are kind of imprisoned. Of course, they're imprisoned at home, and it makes it a little bit easier, but it's still a very restrictive measure. Then there are countries, especially with juveniles, often some kind of social work support is offered. This is a little bit tricky because those offers are actually kind of difficult with the presumption of innocence, if we take it strictly, because I cannot work with somebody who's considered innocent towards resocialization. So yes. Usually this is kind of circumvent with the fact that in these cases the suspect has to agree. But it remains a little bit difficult because the agreement may not be that free either, because of course they want to get out of pretrial detention. Then there's bail, of course. Like in Ireland or in the English-speaking countries, bail is very common, very often used. There are sometimes misunderstandings with bail, because bail gives us, also in Austria, from where I'm coming from, bail is considered just the money, just the money guarantee. But in Ireland, for instance, this is not just about the money. Bail means that they have to pay a little guarantee, but this is adapted to the money available for this person. So this can be very, very little. But also bail stands for other measures included with that. And the interesting thing, at least from my background, and I think also from the Portuguese background and from other countries, is the fact that the suspects are entitled to bail. And that's a different, very different way of contemplating it, because the alternative is actually the measure which has to be applied first. And only then, if this is ruled out, pretrial detention can be applied. And I think I like this idea, and I'm very much in favor of kind of trying to convince others that this could be a way to get people out of pretrial detention. But it's before we get to the alternatives, we really have to. There's a lot of work to be done to convince the deciders, the decision makers, what pretrial detention really means to the people, to the systems, to the states as a whole. And I think there's still a lot of work to be done.
Thank you very much, Professor, for your enlightened presentation, and also to Joana Apóstolo, which is also, I think, helps it out. It was very interesting, and it's a huge topic, I would say, in every perspective. So therefore, we will end. I don't have here any comments or any more questions addressed for you. So we will end then this panel. Thank you very much for your participation. It was very pleased to meet you. And I hope that we will see you soon in this topic and other ones. It was very pleasant to have you here in the CIGEP in this conference.
Since one of our lead partners is from Portugal, there may be good chances that we meet another time. Right, Joana?
Absolutely, yes.
I hope so.
Okay, I hope some people have been with us.
Yes, we will now leave, then we will stay. Okay, so thank you very much for joining.
Thank you. Thank
We
you.
will show the video. Thank you. We are not out of the broadcast. Thank you very much, Professor. We are out of the screen. And I hope that you join it. I hope that you like it. And it was very pleasant to talk with you, to speak with you a little.
Thank you. Thank you. Interesting question. Are you working on the subject?
Yes, I'm actually a lawyer. I'm working in war law, which is dealt also with the imprisonment of combatants. And it is I'm actually seeing the subject of private military security.
Oh, interesting.
So the main questions of violation of fundamental rights, and when they are detained by these companies, what they are doing. We had several problems with that, reliant on hierarchy and so on and so forth. And I'm also very interested in these measures and in these topics and these subjects. So it is very, very interesting for me to hear pre-trial.
For the remaining conference.
Please, pardon?
I wish the best for the remaining conference.
Okay, thank you.
I'm sorry, but I gotta leave because I'm actually filled within. I'm not at my place at home. I've been on a journey now, and but I could arrange to jump in for the conference.
Okay, thank you very much, and
thank
I hope the best for you. Thank you.
Bye bye. Have a good day.
Bye. Thank you.